just briefly what we consider salutary innovations in the proposed federal constitution. Article 1 on national territory. Notice that we have two paragraphs there. The first speaks of sovereignty over the territory, and the second of sovereign rights. Those of you who have mastered public international law already, and even constitutional law, should recognize the distinction between exercising sovereignty over territory and simply having sovereign rights over a territory. Then, Article 3 on the Bill of Rights. Section 1 of Article 3, of our proposed Article 3, says that the rights under Article 3 are actionable and demandable rights against state and non-state agents. What does that mean? Means, of course, that denial, violation of any of your rights under the Bill of Rights can give rise to an action, even actions for damages filed in court. And in addition to the fundamental civil and political rights, we have added what are known as the second generation rights. There are social and economic rights. Please look at every person has the right to adequate food, universal and comprehensive health care, complete quality education, adequate and decent housing, and livelihood and employment opportunities. And so I ask, if my friend does not have food on his table, can he file an action for damages against government, against the state, for the denial of these second generation rights? The proposed constitution gives you an answer that says that the state shall take effective measures in order to assure the progressive realization of these rights. So, definitely, no, not yet. Then we have the inclusion of third generation rights, environmental and ecological rights. If you will notice, if you will look at paragraph C, a right to seek immediate relief from the courts and appropriate governmental bodies through the writ of kalikasan. You have mastered the decisions penned by Justice Presbitero Velasco on the writ of kalikasan and these ecological and environmental rights. Well, when I was examiner in political law in 2016, our chairman was Justice Presbitero Velasco. And the questions we asked were on decisions penned by Justice Velasco. That is where I got the questions from his decisions. And then he added more questions about his other decisions that I did not include in my questions. Anyway, passing percentage in the bar exams, except that there was no Ateneo graduate who landed in the top 10. Because all my kababayans from the Visayas got all the top places. We even heard complaints about the results. When they learned na we were the examiners, some people said, kaya pala naman mga taga-Bisaya ang nag-top. Kasi ang questions were framed in Bisaya. All right. Then we have innovations on suffrage and political parties. First, we have stating and adopting a policy of political parties being mechanisms of citizen representation and democratic governance. We are giving political parties greater powers and more responsibilities. Then we have provided a democracy fund, which will constitute a fund providing for campaign financing of candidates and political parties. Individual donors and corporate donors will be entitled to tax credits if they report the donation they made to the campaign fund, to the democracy fund. Then we have sanctions against political turncoatism. a member of a political party who runs for public office or is elected, if he is elected, he and other members cannot change political party affiliations within 2 years from an election and 2 years before another election. A member of a political party who won in an election and changes political party in violation of the constitutional prohibition will be automatically removed from public office, disqualified from being appointed to any public office, disqualified from running for public office in the next elections. And if his political party spent money for him during the campaign, he is under obligation to reimburse the political party the amount spent for his election. These are, the sanctions we have instituted. Then, of course, our provisions against political dynasties. Our political dynasty provision says no two members of a family related within the second civil degree of consanguinity or affinity shall run in the same election for different public offices, except if one is running for president of the Philippines and the other is not, of course. 2 degrees cannot run at the same time, and we also have a prohibition against running after a relative has completed his term of office. This includes the wife, and there was a move to include even a civil partner of the person who runs for public office. So we have this prohibition against political dynasties. And even as we grant Congress the right to legislate, we said these provisions are immediately executory, and Congress may legislate by providing the prohibition against members of the same family may extend beyond the second degree of consanguinity or affinity. Congress has the privilege of extending this to the third or maybe even the fourth degree. So we hope that this somehow makes up for 30 years of a promise in Section 26 of Article 2 of the present Constitution, that political dynasties shall be prohibited as may be provided by law. Article 6 on initiative, plebiscite, and referendum, we have instituted a principle that abandons Lambino versus Commission on Elections. And so the people may, under Article 6, a revision of the Constitution may be proposed directly by the people, but a petition for the revision of the Constitution through people's initiative must be signed by at least 30% of the total number of registered voters who participated in the last election, and provided that each federated region is represented in the petition by at least 10% of the registered voters in each federated region. Mabigat ng konti ang requirements, pero at least the people may already directly exercise the power of initiative. Then we have the provisions on the constitutional commissions. We have elevated the Commission on Human Rights to the rank or the stature of an independent constitutional commission. And then we have made the office of the Ombudsman a commission type of office. When questions were raised about why we are making the office of the Ombudsman a commission type, Chief Justice Renato Puno said that it is for the protection of the Ombudsman himself, at least with a commission backing up his decisions. It will not be a solitary decision and a solitary running of the entire office of the Ombudsman. Then, of course, on the Federal Commission on Elections, we have decided to take away the quasi-judicial powers of the Commission on Elections. The Commission on Elections may no longer take cognizance of election cases, although the Commission on Elections still has primary authority over registration of political parties and the like. Then, of course, we have the Federal Competition Commission, who is established in order to prevent monopolies, cartels, and market manipulation, to guarantee free and fair competition, and on the whole, to level the business field. These are among the innovations we have instituted on the matter of constitutional commissions. Next is the matter of accountability. The mode of discipline for constitutional officers is still through impeachment. But instead of vesting the power to initiate impeachment in the House of Representatives, we have created a joint impeachment committee composed of senators and members of the House of Representatives. This joint impeachment committee will receive complaints, and the joint impeachment committee will determine whether the complaints are sufficient in form and substance, and having done that, determine if there is probable cause. If the joint impeachment committee then determines that there is probable cause, it will prepare the indictment, the articles of impeachment, and file the same before the Federal Constitutional Court or the Federal Administrative Court, as the case may be. It's really the Federal Constitutional Court in almost all cases, except if the officer being impeached is a member of the Constitutional Court, in which case the impeachment trial will be held by the Federal Administrative Court. On the national economy, in response to the numerous calls for liberalization, etc., we have finally adopted that provision that a lot of congressmen wanted inserted in the Constitution a long time ago, granting Congress the power to provide for a different citizenship requirement in the matter of ownership of natural resources, exploration, operation of public utilities, mass media, educational institution, etc. Provide for a less stringent percentage of Filipino ownership. However, ownership of land remains exclusively with Filipino citizens. Well, nobody could convince the members of the committee that we should open ownership of lands to foreigners. We have also a new article on national security. This covers all three uniformed services: the armed forces, the Federal National Police, and the Federal Coast Guard. I told you earlier that we had a member of the committee who is a retired Major Lieutenant General of the Armed Forces of the Philippines, and he was the one who insisted on the inclusion of an article on national security. Transitory provisions. Let me tell you the story of our presentation of the draft constitution to the President of the Philippines. We presented the draft on July 9, and the President told us to go to one of the rooms in Malacanang. He said he will join us. So he did join us there. And he said, I have really been following, and I am quite satisfied, except that your transitory provisions should include two things. One, a provision that will disqualify me from running for the presidency at any time. He said, go back and include that in the transitory provisions. The other one was, because the transitory provisions we drafted included a provision to the effect that the transition from the present government to the federal government that is envisioned in the proposed constitution is to be presided over by the incumbent president of the Philippines. He said, I do not want to do that. I do not want to be able to be the one to preside over the transition. My suggestion, he said, is that you place there that within 6 months from the approval of the draft constitution, there will be an election of president and vice president. The newly elected officers then to preside over the transition commission. The transition committee that will then manage the orderly transition to a federal government. So that eventually that is what is found in the present draft. Elections. Election of a transition president. We are looking at the term of office of President Duterte expiring in 2022. Under the proposed constitution, he can no longer run for president in 2022. Then, if the proposed constitution is approved in a plebiscite in, say, 2019 or 2020, within 6 months from the plebiscite, from the approval, election for president and vice president. Ostensibly, the term of office of this newly elected president and vice president would be only up to 2022, when hopefully the structure of the federal government shall already be in place. So that we are looking at 2022 and thereafter as the situation of normalcy already for the federal government, for the Federal Republic of the Philippines. Of course, anything can happen because with Congress, anything can happen. But that is what the President told us, and that is what we went back to the drawing board for, and we included these items.